All right.
Do they have a case?
We got a First Amendment speech case here. The city of Alpharetta, Georgia, has a parade every year. The Old Soldiers' Day Parade. Now, it started after the Civil War, and the city runs it. The city pays for it. And if you want to participate in the Old Soldiers' Day Parade, you have to submit an application and tell them who are you and what is your float going to look like and what are you about. And the city says the purpose of this parade is to unite everybody in appreciation of all our veterans. Simple, right? Well, along comes this organization, the Sons of Confederate Veterans, and they submit an application to be in the parade, and the city says, this is great, you can be in the parade, no problem. No Confederate flags, though. Confederate flag, very divisive generally, very divisive in this little city of Alpharetta, Georgia. No flag. You can have your name. You can say what you want. No flags. 3 days later, they sue. I mean, they were ready. They sue, you're infringing on our First Amendment right because you won't let us.
And this is before the parade.
This is before the parade even happened. You're by preventing us from having the flag.
And by the way, that's very important that it was done preemptively before the parade, because if it was done after the parade, then it becomes moot and the court won't even touch it. Then they go, it already happened. Thank you very much. We'll talk next year.
So here's the thing. It has been long established that you have a right to speech and the government has a right to speech, meaning the government can't stop you. But you can't force the government to feature your speech. You can't force them to adopt your speech. So the argument here had to do with, is this parade government speech? Because if this parade is an expression of the city government, then this guy's out of luck with his flag. Well, the city pays for the parade. They organize the parade. They set the theme every year for the parade. This particular year, it was specifically about the Foreign Legion. Not the Foreign Legion, the you know what I'm talking about.
Mm-hmm.
And you have to get an approved application to participate. So the city is saying, we control it. It's our speech. The parade is our message. We allow private groups to come be part of our parade to help spread our message, which is unity. Confederate flag, not unity. We decide. This guy says, basically, I have a First Amendment right to bring the flag in the parade.
Yeah.
So given those two opposing views, how do you rule?
Yeah. I'll tell you what is interesting on this is that the city didn't invoke the concept of public safety. That they didn't say this is a public safety issue because of the potential of protests and violence. And if you look across the country, if you look across the South, we're not making this up. This is legitimate. And I'm surprised because I think that would have been the strongest argument personally. So now this is a good case. This could have gone either way. I am going to argue that the city, in fact, was making a statement, and this falls under the city's right to public speech, because the argument you said, the city made this statement, and private groups come on and join us, but this is our statement, and therefore we have the right to limit it. That's what I would go and say.
That's exactly how it went down. It's the city, and in the appeals court decision, they said, if Flag Guy is right, it would have meant that when the Bill of Rights was passed all those years ago, and you had these parades celebrating it, that the organizers of the parades would have had to allow pro-British people to march with the Union Jack.
That's true. But the concept of the First Amendment has evolved quite a bit.
Yes, that's true.
Since colonial days. There wasn't a Warren Court in those days, to say the least. All right, let's go back and finish up. Do they have a case with Wayne Resnick and me?
All right, this guy says he had a bad lawyer.
Oh, How unusual. Never heard a story like that.
So this guy gets charged with all kinds of fraud counts.
Would you like a list?
Of what?
People who said they had a bad lawyer. I just have to pull my
There's
files.
There's not enough trees in the world to make enough paper to print that list.
Because I have files and files and files.
Is this one of the main calls to Handel on the Law?
No.
People saying my lawyer
No, not one of the main ones. I get no,
Okay.
It's not. It's I get them occasionally where I'll say you need another lawyer. I mean, it's not uncommon, but it's not the main one.
Well, this guy says he got a bad lawyer. He gets charged with all of this fraud stuff. And in the beginning of the case, the government offers him a plea deal. One count of conspiracy, 5-year maximum. Maybe you'll get less. We're not promising anything, but definitely you're locked in. 5 years the most you can do. And his lawyer apparently says, hey, don't do it. Because if you go to trial and you lose, you're looking at 2 to 5 years. So he thinks, well, there's no benefit then, is there? If I plead, then I can't get away with it because I pled guilty. But if I go to trial and I lose, if I'm looking at the same exposure, I should try to fight it. And so he does. And he gets convicted, and he gets 27 years in prison. So he appeals ineffective assistance of counsel. And the court, when you file a thing for ineffective assistance of counsel, the law says the court must have a hearing on your claims. You have to have a hearing unless it is conclusive based on your filing that you're not entitled to any relief. Then the court can say, no hearing for you. So this judge says, no hearing for you, and here's why no hearing for you. You can, yes, your lawyer may have said this to you, and you may have decided not to take a plea deal. It doesn't matter because you came to court and you were arraigned and you were told about the maximum charges and you continued to go to trial and you knew what you were facing. And so he may have screwed up. Maybe he screwed up, but then you came to court and all of that was fixed. All of that, I guess in the law, what do they say? It's the error is cured. Is that what they generally say? That the error,
they do. Whether you're able to cure,
cure the defect in the filing, or you, in this case, you cure the lawyer's bad advice because you got advice
right
before you were convicted and before you were sentenced. You knew, and he says so. He appeals to the appeals court and he says, except what this judge doesn't understand is it wasn't cured because I turned down a plea offer based on his bad advice. And they wouldn't offer it to me again, so I completely lost out on having only 5 years. Does he have a case?
Yeah, I think he does, because clearly that's ineffective counsel. He relied on the advice of his attorney, who screwed up, and look at the damages. This is not what a judge would consider harmless error if there was a trial. This is a guy who did 27 years, was looking at a 2 to 5, and his lawyer wrongly said, you might as well go to trial because you're not going to get more than 2 to 5. That was reliance. That's detrimental reliance on his attorney. So you've got all of this stuff. You knew, the judge says, you knew where you could have gone. My lawyer said no. I was represented. What problem, what part of, don't rely on your lawyer are you arguing? So I think he has a case. As a matter of fact, I think it may very well be overturned based on that of ineffective counsel. I really do.
Yeah, I think what's weird here is it's the opposite of what you normally see. Normally what you see is this. My lawyer told me to plead guilty. I pled guilty and I don't like what happened. So I had ineffective assistance of counsel because he didn't help me make a smart decision about pleading guilty. This is the opposite thing. I relied on what he said to not plead guilty. Yeah. So that's probably why the trial judge, and one thing is I don't think you want to ask a trial judge. I mean, you have to, but to say to the trial judge, I want you to throw out my conviction because I didn't take a plea deal.
Yeah, that is unusual.
And the trial judge wants the last thing a trial judge wants is to have to do a trial all over again.
Yeah, that's but a trial judge easily, and they do overturn verdicts all the time. As a matter of fact, quite often, and this doesn't happen very often. You know this more than others. But asking for judgment notwithstanding the jury. The jury says guilty, and the judge says, I don't care what you say. This guy is walking because there wasn't enough evidence that was presented. And I don't know how often that happens.
Not too often, but I have seen it happen where the judge says, there's no way as a matter of law a reasonable jury would convict. This jury was out of their mind.
Yeah, and that's like asking for remitter when that just happened, where you had that African-American who was arguing against Tesla, and it was a hostile work environment. $137 million, and he was on the job for like 2 years, and $6.8 million compensatory damage. Now, let me ask you, how old was the guy? I'm assuming 30s and his 40s. How much money was he actually making? So let's say he had 20 years left, 30 years left at, let's say, $100,000 a year. Well, there's your $3 million. Where did $6.8 billion come into it? So they give you what I think is astronomical compensatory damage to compensate you for your losses, and then the punitive damages of $132 million. So you ask the judge for remitter, and the judges virtually always in those cases knock it down to a couple $1 million. And the court never reports that. And the media never reports that remitter happened.
Only if it's an unbelievably massive case like a Johnson & Johnson baby powder case or one
I think even the remitter came down on that because juries gave an individual plaintiff $1 billion.
Yeah.
I mean, come on. I mean, I'll get as sick as you want for $1 billion. I'll take my entire family down for $1 billion.
No.
As a matter of fact, I don't even want to go into how much I would actually accept for that.
That is good. Anyway, he gets to go back and make his argument there.
2 out of 2. Today was good.
Yes.
All right, we're done, guys. That was fun. Always is. Back again tomorrow where we start this all over again. Bill Handel here. Handel and the Morning Crew. KFI AM 640 live everywhere on the iHeartRadio app.